Internet legal topics of the day. This is your home for the latest on internet law and policy. Hear the latest net trends impacting business and have your questions answered right here. This is the Cyber Law and Business Report. Now, please welcome your host, the founder of the Internet Law Center, Bennett Kelly.
Hi, this is Bennett Kelly with the Internet Law Center in Santa Monica, California, and I'm the host of Cyber Law and Business Report. The following is an excerpt from the May 30, 2012 Cyber Law and Business Report featuring Chairwoman of the California Fair Political Practices Commission, Anne Revelle. It was a special edition broadcast live from my alma mater, Georgetown University Law Center, that focused on disclosures in both commercial and political speech. We were in Washington since, it was spring, and that usually is a pretty good excuse to be there, but in particular because across the street, the Federal Trade Commission was holding a workshop on advertising and privacy disclosures in a digital world that would lead to changes in its .com disclosure requirements and are discussed in the first half of the show but not included in this excerpt. The workshop came after the FTC had released its so-called blogger guidelines in connection with its updated endorsement guides, which had drawn mixed reaction amongst the blogosphere. In the second half, we spoke by phone with Commissioner Revelle in Sacramento about a recent trial balloon she had made regarding applying the principles of the blogger guidelines, namely disclosure of sponsorship or affiliation, to the political arena when it came to endorsements of candidates or propositions. It would not be until September 2013 that the Commission would adopt some form of this rule. Governor Jerry Brown appointed Revelle to the Commission in 2011. Prior to that, she had served as Deputy Assistant Attorney General under Attorney General Holder under President Obama. Revelle also served as County Counsel for Santa Clara County for more than a decade and was recognized by the California Bar as Public Attorney of the Year in 2007. In June, President Obama nominated her to the Federal Election Commission. Our discussion with Chairwoman Revelle follows. Thank you for listening.
Exactly is that, and how does it differ from other states?
The California Fair Political Practices Commission was established by initiative of the voters, like everything else in California, after Watergate. And the purpose of it was to restore public faith and trust in government. And ultimately, because of that, faith and trust in government, people would be encouraged to participate in politics, run for office, become more engaged in their communities. The FPPC has a really broad scope of responsibilities. We regulate campaign financing and spending, financial conflicts of interest, lobbyist registration and reporting, post-government employment, mass mailings, gifts, etc. I think the way that this is somewhat different is that the commission itself is an independent, nonpartisan commission, independent of the governor and the legislature. I'm chair, and I was appointed by the Governor Brown in 2011, and the four other commissioners are appointed by various constitutional officers of the state, but there needs to be a balance of political parties.
Now, you would differ from other states where the person with this type of responsibility would be maybe housed in the Secretary of State's office, for example?
Exactly. And I think that's the difference. In California, the Secretary of State is a partisan office. We are totally independent as a commission. We have a base level of funding. We're also permitted to fundraise to augment our funding. And, of course, we also get augmentations in the yearly budget. But definitely this commission operates independently, and in order to change our statute, there has to be either a two-thirds vote of the legislature or a vote of the people.
Now, you're appearance today is very timely because I'm calling to you from Washington. I'm right across the street from the Federal Trade Commission, which is right now having a conference on updating its disclosure guidelines for e-commerce and mobile commerce.
Right.
And so, what are the appropriate disclosures that need to be made in a commercial setting? Particularly where there's conflicts of interest. And so you dipped your toe in this water in the political setting.
Yes.
And
go ahead.
No, and do you see any similarity between the two, or just the kind of the basic harm to consumers that you were concerned about, whether it's a political consumer or a financial consumer?
Right. It was actually the FTC disclosure guidance that was the impetus for my thinking about proposing such a thing in the political arena. Although I actually think, while I'm concerned about consumer rights and think of that as part of the basis for this, I think that in the political arena it is more important, actually, because rather than just a financial impact, which is serious enough, and I think consumer rights are serious, but the decision about how to vote is often based on voting queues, because people simply don't have the time to look into all of the issues, whether it be about a candidate or about a measure. And so they take cues and they pay attention to what others write. And since now, and I saw this, there was a Pew Research Center study about how most people are now getting their information about politics and news from mobile devices, from internet kinds of information such as blogs. It seemed to me that this was an opportune time to start the discussion about this really important subject.
And you make a good point, because I think a decision over what toothpaste to buy versus a decision over a United States senator who can confirm treaties and Supreme Court nominees. There seems to be a great disproportion in terms of the weight of one decision versus the other.
Exactly. And even on the local level, where since I came out with this proposal, I not surprisingly have gotten a lot of feedback, negative and positive, and a lot of people have talked about the purchasing of opinion on the local level in local campaigns, and local governments can have an enormous impact on people's everyday life.
And I hope, as we've seen here in California, in the town of Bell, where we had kind of like a racketeering outfit that was running the town and getting $1 million salaries. So, how prevalent do you think buying influence is in the blogosphere?
It's hard for me to gauge, but the reason, aside from my emulation of the FTC, that I thought about this issue was a fairly prominent blogger in California wrote to the FPPC and asked us whether we had any rules that governed his activity in this arena, because he indicated that he was being paid by a party. And so it led me to think that this is quite prevalent, and I have since heard from a number of people that it is definitely prevalent, whether it be direct payments or in the form of, and this came out during the gubernatorial campaign in California, that apparently Meg Whitman's campaign paid a blogger for placing an ad on the blog, but paid an enormously inflated amount for that advertisement that was so much more than what would have been paid by anybody else in the normal course of commerce. So that was one mechanism to receive positive blogs about the campaign.
So I had last week on our show, we had Raven Brooks from Netroots Nation, which will be next week in Providence. And I mentioned that you were going to be on the show this week. And he wondered whether the objective of this type of approach was really to regulate in terms of whether people are disclosing conflicts of interest, that somehow their opinion is somehow bought, or whether it was really just trying to flesh out adequate disclosure of campaign spending.
It's actually both. I think there needs to be adequate disclosure of campaign spending, and that's another initiative that I'm involved in relating to, in particular, independent expenditure spending. But I do think that some campaign spending is not adequately being disclosed in California, and probably on the federal level as well, as we know.
Probably.
But I also think that it's very important for people to know, and that's part of what disclosure is about, the source of funding, so that they can make a determination as to whether an endorsement is misleading, whether somebody has, as the FTC has said, a connection between the endorser and the campaign, which would make a difference in how people evaluate the endorsement.
Right. And I mean, if I'm claiming I'm an ardent environmentalist and my blog is being funded by pollute.com, then yeah, that definitely educates people. Now, the proposal is not on the table at the moment, correct?
That's correct. And given some of the extreme responses that I've received from bloggers, and I'm a great believer in getting all of the commentary on the table, getting input. What we've decided to do in the interim, because it's probably not going to be something that can be implemented quickly, is to have what we call interested persons meetings, to have people come forward, talk about other potential ways of approaching this, at least in the interim, such as getting the campaigns to disclose the money that they're providing for opinion in a much more granular way, so that and in a way that we can put on our website, so we can pull it out from their campaign disclosures more easily.
Although there still is the issue of consumer consumption, because yes, it's on your website, but when I read blah 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 blog, and even though on your website it says that his opinions are entirely funded by these companies, on his blog that's not disclosed, and so I'm not aware of that unless I go to your site, which I'm sure not too many people do.
Right. No, you're absolutely right. I mean, there's two aspects to that. One, definitely we want to make our website the go-to place for political information in California. But yes, I agree, it's not an ideal resolution. The ideal resolution is having it in the same place at the same time that the opinion is being provided.
And given that we're talking about political speech, is it best to not regulate and then let the regulation occur through counter arguments, or is it better in some cases where it's just so egregious to have some kind of prohibition or some kind of template that has to be disclosed in certain circumstances?
Right. Yes, we're talking about political speech, but clearly political speech can be regulated in the sense of not the content of it, but some of the source of it. So I think that
format,
Yes, and we require in California very clear. Of course, this is of campaigns, but on advertisements, we require that they indicate not just the name of the committee, but the top funders of the advertising. And that's political speech, and we do it for independent expenditures as well. So I think that there is some precedence for providing this kind of information. But you're right. That is an issue that has been raised by the bloggers, arguing that this is a First Amendment intrusion and that it is inappropriate to require them to identify the basis for their speech because they should be able to speak freely.
And make money.
and make money.
It's kind of parallel to the debate we're having over campaign finance, where should there be limits or should they just have simultaneous disclosure?
Mm-hmm.
If you know what they're getting, what's the harm if they're getting boatloads of money? As long as they disclose where it's coming from.
Right.
And I think that's part of the debate that is happening in the post-Citizens United world.
Yes. And those are the kinds of debates that should be more common, actually, because I think as chair of the Fair Political Practices Commission, I have noted that a number of the rules that we have don't serve the purpose that they were intended to serve. So it makes sense for us, rather than requiring campaigns or public officials to go through a lot of effort in filling out forms, that we need to think about what kind of information the public needs to know in order to be able to make thoughtful decisions in both about their public officials and in their communities, as well as about candidates.
So the proposal is off the table, and you're having stakeholder meetings and discussions about what to do. Is it possible there might be some kind of just suggested best practice for this election, or there really isn't likely to be any guidance for this election?
No, I would very much like to have a suggested best practice. In fact, when I made the proposal, that was what I indicated initially, because I know that's how the FTC did it.
I was going to say that's also the FTC model, yes.
Exactly. And so that was my proposal, was that it would be done as a suggestion. I indicated that I would like to see it happen as regulation. But in part, that's something that I think needs to be pursued. But I also think the conversation about this has to be more common, because this is something that people knew about but was not disclosed to the public. Most people do not know.
We're running out. I'm afraid we're out of time. I want to thank you very much for joining us. It's been an honor to have you. And if people want to learn more about this issue, where should they go?
Well, they are able to go to the FPPC website, where we have some information about our both this issue and other issues, and also we will have information about our proposals. And the FPPC website is FPPC internetlawsummit.ca.gov.
Well,